Have never, if you're like me, when I was in undergrad, you probably don't spend a lot of time thinking about administrative law or administrative agencies, right? I mean, you're pretty much worried about what's the drinking law and, what's landlord-tenant law, maybe, okay? But I think that when you're in the business world, administrative law is actually I don't know if I want to say it's the most important source of law, but it's the most frequent source of law that you're going to come in contact with. I mean, I think our Constitution is the most important source of law always, but administrative law is kind of everywhere, okay? And it is going to exist at multiple levels of government. So you're going to have federal administrative law, you're going to have state, in some cases you're going to have county, and in some cases you're going to have city administrative law. So you might have up to 4 different sources of admin law, and in fact, when we're talking about employment law or anti-discrimination laws, if you're in a city over 20,000 people in Iowa, you're going to have at least 3 layers, maybe more, okay? And administrative law comes out of administrative agencies, so these kind of alphabet soup agencies that you don't necessarily hear of or think about a lot until they maybe do something dumb and they're in the news, right? But they really, really influence how we do business every day. They've been around since 1887. That was the first federal admin agency. And we've got more than 50 of them at the federal level. And it's hard to keep them straight, so allow me to show you some Russian propaganda about how difficult it can be. I want you to know when I clicked on this link to bring this up, it had an ad for the NRA that came up too. So take from that what you will.
And I will.
The head of the agency that he couldn't remember. What a country. He's the boss. He hasn't done away with it either. What a country we live in. Now for a more sober view of administrative law, our Chief Justice of the United States, Justice Roberts, unsurprisingly has some intelligent things to say about this, all right? And in this quote here, what he's addressing is one of the common criticisms of administrative agencies that you kind of just saw in the debate. There's too many of them, we don't know what they do, and they've got too much power, right? And I'm going to explain some of the reasoning behind some of those criticisms. And, some people even say, well, it's unconstitutional. There's nothing in the Constitution that mentions administrative agencies, right? We've got Article 1 for the Congress, Article 2 for the executive, 3 for the courts. Article 4 does not establish administrative agencies, right? It's something different. And he's saying here that, these agencies, well, okay, they fit inside the executive branch for the most part. And we'll sort of talk about where they fit. But, they exercise legislative power as well. And they have a judicial function as well, okay? So that's unusual. But it's not an exception to the Constitution. It's a central feature of government. And I'll attempt to explain the reasoning behind having administrative agencies. But getting to what he said, these agencies act in the manner of all 3 branches at different times, just within their own agency. So they make laws, they interpret laws, and they enforce laws. How can that be? Don't we have a balance? Don't we have separation of powers, checks and balances? We do, and this is not an exception to that, but it is kind of a microcosm in some ways. So let's talk about these things. Just want to check out. Okay. Let's talk about these things, these agencies. How do you make them? Why do we have them? Powers do they have? And what are the limits? Okay. Well, I like to say that administrative agencies are in some ways kind of the subject matter experts in our government. All right? So picture yourself as a lawmaker, a congressperson, a senator, right? People come to you, your constituents come to you with problems, okay? And it's your job to try to figure out what to do about those problems within the bounds of your power. So suppose you're back in the 1900s or whenever, and people come to you and they say, we've got all these factories and they're polluting the air, they're polluting the water, they're killing the fish, people are getting sick, right? Too much pollution. Senator, we want you to do something. So most lawmakers are kind of generalists, right? They can come to that job from any walk of life, but most of them are not scientists. In fact, it's quite rare, right? A lot of lawyers, other folks. So you get enough lawmakers in agreement on a problem, and they say, yeah, we should do something about this. Okay. Do they have the expertise to sit down and write really detailed environmental laws? No. Do they have the scientific background to know how many parts per million of a substance is harmful? No. Right? What they can do is set up an agency and staff it with people who are experts and direct them to study the problem, create rules, and enforce those rules. So in this case, they created the EPA, the Environmental Protection Agency. And Congress gives this new agency a mandate, if you will, in the form of this enabling statute. So this is kind of the rules of the game for the agency. Once you create an agency, it doesn't just have unlimited power to regulate wherever it wants. It can only regulate in the area in which you give it power. It's kind of like setting up a corporation, right? You have some people, but you're going to set up some guidelines and some rules for how they can act. So you set up this enabling statute, and that includes how the agency's set up, what its mission is, how it's going to be funded, what the rules are, where the limits on its powers are, and things like that. And then the agency is staffed with people who can carry out its mission. And there are different kinds of agencies for different kinds of regulations, and we'll talk about those. But that's generally how you get one of these things moving. All right? Now, of course, there are laws about the law and rules about the rules there. So this body of law that we call administrative law not only includes the substantive things that these agencies come up with, the rules they come up with, but it also includes the rules about setting them up, okay? So defining the authority and the structure of administrative agencies in the U.S. or at the state level. So Congress follows something called the delegation doctrine in doing this. It delegates some of its responsibilities through that enabling statute, and that enabling statute is a law that Congress passes, and it sets up this agency, okay? So they are kind of, I don't want to say they're children of Congress, but essentially it's Congress that sets them up and gets them going. Within the agency itself, they exercise powers that look like all three branches of government, however. But they're still limited to the mission for which they're set up. And as you might imagine, there are different kinds of agencies out there. Not only different in subject matter, but different in their role in our government. So we've got these independent agencies that are more like kind of watchdog agencies, and then we've got executive agencies, and these are more like helpers, okay? The independent agencies, they're created to enforce federal laws that Congress passes, and here we think about agencies like the EPA, the Equal Employment Opportunity Commission, the FCC, they regulate the airwaves and communications, National Labor Relations Board, the SEC, all right? So these are kind of watchdog agencies. They're not so beholden to the president or the governor at the state level. In fact, sometimes they clash, right? And in recognizing that, these folks who head the agencies usually have a set term of years, and the president has to have good cause to remove them. Okay, now they're appointed by the president and confirmed by the Senate, but they can carry over from administration to administration. So they don't enjoy a lifetime position during good behavior like a federal judge, but they're a little more insulated. So if the head of the EPA clashes with the president about pollution, it's not a given that he or she is going to get fired. Okay, they have some protection. Now the executive administrative agencies, on the other hand, they're much more tied to the politics of the chief executive, whether that be the president or the governor, because they are created to assist the cabinet offices. So you've got agencies such as the FDA, and that's within Health and Human Services. IRS is in the Department of Treasury, U.S. Patent and Trademark Office within the Department of Commerce. There are many more than I've listed here. But these top managers are appointed by the president and serve at the president's pleasure. So that means essentially he can fire them and replace them whenever he wants. Okay? As an example, the FTC. This is a federal agency created by Congress in 1914 to prohibit unfair competition and deceptive trade practices. All right? So you're probably familiar with the FTC if you're ever following a company that maybe is going to go through a merger or an acquisition or a stock sale to another entity or asset purchase or whatever. They kind of monitor things related to competition in the free markets, right? And so under their enabling statute, they've got the authority to create rules and regulations, conduct investigations of business practices, obtain reports from corporations that function in interstate commerce, investigate violations of federal antitrust laws. Those are anti-monopoly laws. And this last one kind of interesting. They can hold trial-like administrative hearings to resolve certain kinds of trade disputes. So we haven't talked about this a whole lot, but agencies have sometimes judges within them, folks who act just like judges. Sometimes we call them ALJs, or administrative law judges. And although they're not the same kind of judge as spelled out in Article 1 or 3 of the Constitution, they have many of the same powers within their subject area. All right? So if you are proposing some kind of merger or there's some kind of anti-competitive trade practice that's going on with your company, you might find yourself before an administrative law judge within the Federal Trade Commission. And that person is going to hold hearings, and for all intents and purposes, it's going to be very similar to a trial in a state or federal courtroom. Another example of enabling legislation. So we're going to talk at considerable length later in the class about employment law, right? So Title VII of the '64 Civil Rights Act prohibits employment-based discrimination. And here's another situation where Congress is saying, okay, this is a problem. We need to fix the rampant discrimination that's happening in employment, but we're going to need more. We're going to write some laws, but we're going to need more than that, because who are people going to complain to when they think they're being discriminated against? Who's going to investigate these complaints? Who's going to hear the complaints? So they set up the EEOC to do those functions. All right. The EEOC can make rules about what's a discriminatory practice in employment, or what isn't, and they can make investigations. You can file a complaint with them if you've been discriminated against at work, and they have kind of a first hearing level for workplace discrimination cases. We have agencies at the state level as well. So thus far I've just shown you some federal ones, all right? Let's take a look at how many agencies we have at the state level. Hopefully this loads here. Perhaps the Russians have hijacked my browser. Nope, there we go. All right, so as of last week, these are our state administrative agencies. Got a whole bunch here, right? Just keeps going and going. It's a lot. We have a lot of different ones, all right? Some of these are pretty important. Now, and I don't want to put down any administrative agencies, but the Turkey Marketing Council looks interesting. Yeah, not a lot here. All right. So they've got basically one chapter in their enabling statute, and it has to do with refunds on turkeys. That's interesting. Another one that actually has quite a bit is the Egg Council of Iowa. I don't know how many of you guys grew up and had chickens. We have chickens on our farm. We raise eggs. But this is really big business in Iowa. We're often the #1 egg producing state. And so you can see that the Iowa Egg Council has a fairly robust enabling statute. And it talks about the organization and the purpose. It talks about officers, meetings, what's a quorum. I mean, it goes on and on. You've got definitions. You've got informal settlement of controversies, in case you're walking on eggshells, I guess. Terrible pun. So we've got a lot at the state level, all right? You know, the Iowa State Fair has its own administrative agency just for setting that up and running it every year. Most counties have one for their county fair. You know, those are kind of the lesser known. I won't say less important. You know, but some of the really notable ones, well, our Civil Rights Commission. That's the equivalent of the EEOC at the federal level. So it investigates discrimination in the workplace. They also have some of the other functions too, like discrimination in housing and lending and things like that. We've got a banking division, regulates all of our banks. Insurance, Law Enforcement Academy trains all our officers. Homeland Security has to do with our security of our state. Professional Licensure Division licenses everybody from doctors to lawyers and beyond. So there's a whole bunch of different areas here where we have these agencies, and you know, they kind of touch on everything you do. If you guys have ever looked at starting like a food cart or even selling food at a farmer's market in a larger city, you come into contact with the County Board of Health, right? And the rules and regulations there are lengthy. So, you know, even starting a very small business puts you in touch with these agencies. Or you ignore them at your peril, right? You go out and start your food cart, and all of a sudden somebody from the county department of public health says, hey, do you have a license for that? By the way, was that prepared in a commercial kitchen? Did you have a 3-compartment sink? Did you rinse your utensils at a certain temperature, and so on and so forth? And if you don't comply, you don't get to sell your product, right? So just kind of showing you here a couple more county and local agencies. Public health is a biggie for most counties. We've even got city departments, fire, public works, senior center, things like that. There's a lot there, okay? So I said that agencies sometimes act in the manner of Congress itself, from which they are created. What does that mean? Okay. Well, agencies get to make rules, and those rules have the force of law. The object of them making the rules instead of Congress as a whole is that these folks have more expertise. In other words, the public health folks know way more about public health than the average congressperson, or whatever the topic is, pollution or discrimination or whatever. And so they make these rules, and these rules become law. So if you're doing business, you not only have to know the statutory law that impacts your business and the cases or common law that impact your business, but you have to know this administrative law as well. Okay? And it can be pretty lengthy. This is just a 2-volume set of administrative law. I don't remember what subject matter that was, but if you look at the Iowa Administrative Code, which you can get for free online, there's a lot there, right? So substantive, or sometimes called legislative rules, are getting to the subject matter area of that agency, whatever it may be. All right, so this guy here is welding, and OSHA is a federal agency that governs workplace safety. All right, so OSHA makes rules like if you're going to employ welders, you have to give them face protection and eye protection, and maybe you have to have some signage, up like this, right? So when OSHA makes that rule, it becomes just as powerful, if you will, as a law passed by Congress, all right? And businesses are required to follow those laws just like they were created by Congress. Sometimes you get interpretive rules. So the IRS is a good one for this. The tax code is rather complicated, and it's just changed completely. One of my friends who's a CPA shared a link that the Association of CPAs is asking the IRS to clarify big parts of the tax code for preparers and for businesses, all right? So when an agency gives interpretive rules or guidelines like that, these are kind of non-binding but advisory things saying, this is how our rules work, okay? Maybe it's going to be in the form of talking about a certain rule, or maybe it's going to be a handbook saying like the top 10, most common areas where employers get in trouble with discrimination laws or stuff like that. So you go to the page of any good administrative agency, and it's probably got some interpretive guidance on it, okay? And this is done to help businesses comply. One way to make sure you're in compliance is to have compliance professionals, or if you're a small business, have a lawyer that can help you kind of understand and navigate these different rules. But the agencies usually try to do their best to put some understandable things out there as well. And then they can make procedural rules as well, all right? So like the FCC gives procedural information to the public about the processes by which they enforce their laws. So when cell phones were kind of a new thing, which was quite a while ago, people were so excited about it that they would sign whatever contract the cell phone company would put in front of them. And it used to be that you couldn't take a phone that you bought from Verizon and use it on Sprint or vice versa, and there were big fines if you didn't turn your phone back in when you switch contracts, and some contracts went for years and years and years, and you'd have to pay a big penalty if you got out, and people were unhappy, to say the very least, and this came under the purview of the FCC, and so they made rules about how you could file administrative complaint against these cell phone companies. All right? So procedural rulemaking, probably not the most common or important example. I really think the substantive rulemaking is what is going to affect most people. So you're saying, wow, these agencies have a lot of power. Okay, they're out there, they're making these rules. It's not Congress where I can go watch or get a daily update on what bills are pending. How do I know what they're doing? And is there any kind of check on their rulemaking ability? Well, yes, there is. So we have something called the Administrative Procedures Act. It's a federal law, and it essentially says this is the process by which an agency can make rules, because they're attempting to make it fair and just for everybody who's affected. There's two different ways these agencies can make rules, formally or informally. Now, the informal way is still relatively formal, okay? But it's just a little bit less so, okay? So in informal rulemaking, sometimes we call it notice and comment. The idea is they tell you what they're doing, they give you a chance to complain. If not enough people complain, it's going to go forwards, in a nutshell, right? So there's this thing called the Federal Register. It used to come out in a paper format, and then I think it would come out of a fax machine, and now I'm sure it's online, where every day you would get kind of an update on all the proposed rules that were coming out, and it would be in there. And maybe this is for a relatively minor rule, and so they say, here's what we're thinking of doing. This is the rule we're thinking about making. We're going to have this open to comments for 30 days or 60 days. All right, people can write in. And then they're going to take those comments, they're going to read them, and then they're going to decide, do we go ahead with the rule or not? All right. Once they decide, yeah, we are going to go ahead with it, it's published in its final form, becomes part of the Code of Federal Regulations. A more formal thing for like a big change is going to include a public hearing of some kind. All right. So they publish the proposed rule, and then they have this public hearing where people go and testify, yay or nay. Then a decision is made, and if the rule is changed, it's published. So like a couple years ago at the state level, there was a proposal from it must have been the Professional Licensing Board, I'm not sure exactly, but that attorneys law students who completed their law degree in Iowa would have a diploma privilege, like in Wisconsin. And this just meant that if you did your law school here or at Drake, you wouldn't have to take the bar exam to get a license to practice law. And this went through the formal procedure. And a lot of lawyers came and said, we think this is a bad idea. And so that rule did not pass. All right? Just kind of an example. This is just an example of OSHA here for informal rulemaking. So administrative law rules are more detailed than statutory law, and they kind of fill in the gaps left by statutes. So when Congress wants to regulate in an area, they can do so directly, or they can establish an agency. It really often depends on how technical the area is. Remember that they're created by the legislature, given their authority by the legislature through an enabling statute. And the mechanism by which they act like different branches of government. So they create rules, kind of like the legislature. They enforce rules or can make investigations, kind of like the executive branch or president. And they often adjudicate cases like the judicial branch. an example of filling in the gaps of a statute. So we had a federal law that says gender-based discrimination in the workplace is illegal. Then a sexual harassment case comes up, and we had to answer the question legally, is sexual harassment a gender-based discrimination, right? One way is a court could decide, or another way is for the EEOC to issue some rules and guidance on that, and then, of course, they said, yes, it is. So I think it's a good place to stop for today. Yeah. Good morning, everybody who just woke up. I know it's not the most exciting thing, but it is really important. We'll come back next time and talk more about the powers of these agencies. And good luck with the papers.